Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone. Today I've got counsel Paul Dhaliwal with me on the Legally Speaking Aitken Robertson YouTube channel. And today we are delving into an important aspect of the legal system and exploring what it means for you. Today we'll be discussing your charter right, and that is the right to be tried within a reasonable time under Section 11B. So if you've ever been involved in criminal charges, you will know firsthand that it can feel like a never ending journey, plagued with delays and frustrations. But did you know that there are protections in place against unreasonable delays? So, Section 11B of the Canadian Charter of Rights and Freedoms guarantees that individuals charged with criminal offences the right to a trial within a reasonable time. So, let's dive in. Okay, Taryn, so what does a reasonable time mean?
So it really depends in terms of how the matter is proceeding. A criminal case can proceed in the Ontario Court of Justice, or it can proceed in the Superior Court of Justice, depending on the type of offense. Most offenses under the Criminal Code of Canada are considered hybrid offenses, and so the Crown Attorney has the ability to elect whether they want to proceed summarily or whether they want to proceed by indictment. For example, in the States, a misdemeanor would be akin to a summary offense, and a felony would be akin to a indictable offense. For any cases that proceed in the Ontario Court of Justice, the ceiling is 18 months. For any case that proceeds in the Superior Court of Justice, the ceiling is 30 months. And all of this was established in the Supreme Court of Canada's 2016 decision called Jordan.
Thank you. So, what does it mean if a trial takes longer than the presumptive ceiling? Will it automatically just be an unreasonable delay?
There's a number of factors to consider when bringing these types of applications. The judge will have to analyze, and the defense and the Crown, what the total delay is in the case. And then they would have to do a calculation to determine what the actual net delay is. Certain portions of a criminal matter could be considered delayed at the feet of the Crown. For example, if the Crown Attorney is not providing significant disclosure in a reasonable amount of time, that can be considered a Crown delay. There can also be defense delay. For example, when a defense lawyer is not available for certain trial dates, or, for example, if the accused individual is not cooperating with the defense lawyer, for example, that's another consideration that can be considered a defense delay.
And then, which of the delays counts toward the net delay?
So the net delay, again, it would be a subtraction of all of the defense delay and a determination of what the reasonable time limit should have been for the matter to proceed to trial.
So, if the delay is over the presumptive ceiling, what happens next?
In a case where the delay is above the presumptive ceiling, the onus is on the Crown Attorney to establish, for example, a exceptional circumstance or something that would mitigate that sort of delay. If the Crown is unable to show that there were some other considerations that affected the matter, for example, if the trial was overly complex, or if this was in 2020 or 2021, perhaps even 2022, COVID considerations would be another factor for the judge to consider in terms of the matter taking longer than it should have.
Okay, and then if the delay is under the presumptive seal, will an application under Section 11 be filed?
Not necessarily. There's been several stays of proceedings granted by judges for delays that are under the ceiling, but the circumstances of showing that is different than if the delay was above the presumptive ceiling. The defense lawyer would have to show that the defense was diligent and demonstrated sustained efforts to expedite the proceedings. And the Crown Attorney would also have to consider if there were other circumstances that account for the delay being reasonable in the circumstances.
So, what happens if the court agrees that this has taken too long, the trial has taken too long? What happens next?
So if the judge agrees that the Section 11B rights of the individual have been infringed, the judge would essentially grant a stay of proceedings pursuant to Section 24(1) of the Canadian Charter of Rights and Freedoms. And a stay of proceedings is essentially the most powerful remedy available to address the infringement of an individual's constitutional rights under Section 11B and under Section 24(1) of the Charter. A stay of proceeding is essentially tantamount to an acquittal in the sense that it effectively brings the proceedings to an end in favor of the accused.
Okay, well, thank you. Thank you so much, Taryn, for joining us today to discuss the right to a trial within a reasonable time. How would clients get in touch with you?
The best way would be to go on our website, fightthecharges.com.
Thank you. And thank you, everyone else, for joining us today on the Aitken Robertson YouTube channel. And don't forget to like, subscribe, hit the notification bell so you don't miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.